Thank you and welcome back to our viewers and listeners. Our next speaker is a renowned media lawyer, written several books, a partner and attorney Weber Wenzels in Johannesburg, Mr. Dario Milo. Thank you, Dario.
Thank you. Thanks, everyone, and good morning. And I'd especially like to acknowledge the presence of the Minister and Advocate Lakula. It's a great privilege to be able to address you today. I want to do 4 things this morning, briefly. First, I want to say a little bit about the difference between civil and criminal defamation. And of course, many of you will be aware of this, and I apologize for that. But I think some of the basics are important to get out the way. And also a little bit about its history. Secondly, I want to talk about how criminal defamation differs from hate speech. Many of you would have seen in the title for the workshop a reference to Charlie Hebdo, and I'd like to talk about that very briefly. Thirdly, I'll look at the recent developments in Africa and jurisprudence as it's developing. And in particular, I'd like to look at the Zimbabwean Constitutional Court's decision of last year and the African Court's decision, which are both seminal decisions and cases in the field of criminal defamation law. Finally, I'll briefly set out what the South African legal position is, although my learned colleague Les Morrison will deal with that in a lot more detail. But I'll argue that criminal defamation is plainly unconstitutional, and the ANC's decision and the Minister's announcement that it will be eradicated from our law is clearly the correct constitutional decision. So firstly, let me begin with a brief working definition of how the civil law of defamation differs from the criminal law. Civil defamation, as you'll know, is a legal remedy to compensate people for harm to their reputation. The object is the vindication of their reputation, where they have been unlawfully defamed in the eyes of reasonable people in our community. And examples are many. I've been involved in a number of cases, and the facts, of course, differ. But to give you 2 examples, in LaRue versus Day, in the Constitutional Court, the deputy headmaster of a school sued 3 students who created an image of the deputy headmaster and the headmaster of the school in a sexual position, and the deputy headmaster thought that that harmed his reputation and sued. That's the one category of case. And of course, there are many cases where high-profile and prominent people sue for defamation, such as Robert McBride suing The Citizen for publishing editorials and columns that stated that he was a murderer who ought not to be appointed to important public office. So our law allows the successful plaintiff in those kinds of cases who succeeds in showing defamation, and where the defendant does not succeed in showing a defense, to claim damages, to compensate for the harm to their reputation, an apology, and even an interdict to stop further publication of that defamatory statement. Criminal defamation, on the other hand, is of course enforced by the state. A charge gets laid against you, the police investigate the charge, you may be arrested, there may be a prosecution by the National Prosecuting Authority, and if a court convicts, the defamer is punished either by a fine or imprisonment. The purpose of criminal defamation, though, is also the same as the purpose of civil defamation, and that is to restore the complainant in that case's reputation. And therein, of course, lies most of the constitutional difficulty, that you already have the purpose of the criminal law achieved by the civil law, and I'll come back to that. How did we get here? How did it arrive in our law? And the Minister has already referred to its origins and its colonial origins. Essentially, we have a combination of Roman Dutch law, who inherited the concept of criminal defamation from Roman law, and English law. In early Roman law, someone who recited words that harmed another person, particularly a person in public office, was a crime, and it was punished with the death penalty. In the 17th and the 18th centuries, the crime was regularly prosecuted in Holland and was seen in a very serious light. And so it was imported into our law. Commentators have said it's difficult to discern the precise rationale, but some authors trace it back to the desire of those in power, and particularly rulers and governments, to maintain the social class structure and the status quo. And even in England, the crime was abolished in 2009, with the then Justice Minister saying it was an arcane offence from a bygone era when freedom of speech wasn't seen as the right that it is today. I need to take a very brief detour here just to distinguish hate speech laws from criminal defamation laws. In my view, hate speech laws may well be constitutional as long as they are narrowly tailored to reach the threshold for hate speech which is defined in the Constitution. As you'll know, Section 16 of our Constitution has a broad protection for freedom of expression, but Section 16.2 excludes from that protection a number of categories of speech, such as incitement of imminent violence and also hate speech, being the advocacy of hatred based on race, ethnicity, gender or religion, and which constitutes incitement to cause harm. So unlike words that are defamatory, which are, as a starting point, protected by our Constitution in Section 16, and then there's a balancing that occurs with dignity and reputation, hate speech is expressly not protected under our Constitution, and justifiably so, because of our history. So narrowly tailored hate speech laws, unlike criminal defamation laws, would be defensible in our democracy. Now that I've set out the basics, I'd like to discuss some very positive developments around the continent in the last year. And in fact, the place to start is in 2010 with the resolution of the African Commission on Human and People's Rights on repealing criminal defamation laws in Africa. The Commission said criminal defamation laws constitute a serious interference with freedom of expression and impede the role of the media as a watchdog, preventing journalists and the media from practicing their profession without fear and in good faith. Despite this resolution, no progress had taken place. But all this changed with two decisions last year: a December decision of the African Court on Human Rights and a June decision of the Zimbabwean Constitutional Court. I'll begin with the African Court decision, which dealt with the law of criminal defamation in Burkina Faso, which of course is also in the news at the moment. Konate, a journalist working in Burkina Faso, was charged with criminal defamation for defaming the state prosecutor. He was convicted and sentenced to 12 months imprisonment. He was also given a severe fine, hefty damages, ordered to pay costs, and his weekly newspaper was banned for a period of 6 months. He approached the African Court, and I'm happy to say that the court unanimously found that Konate had been wrongly imprisoned. The majority of the court, 7 judges, found that criminal defamation was not necessarily bad in principle, but a huge problem was the sanction of imprisonment. And the judgment found that criminal defamation therefore could not be punished via custodial sentences. It was an important advance in our law of criminal defamation. The court incidentally also overturned the other remedies that had been granted against the journalist. So the banning of the newspaper, the damages, the costs, all of that was regarded as disproportionate. But it's noteworthy that our very own advocate Tlakula, who's here today, the special rapporteur, says in response to that decision, this is a landmark decision that will change the free speech landscape on the African continent. It will give impetus to the continent-wide campaign to decriminalize defamation and also pave the way for the decriminalization of similar laws. Now, the minority judgment in that case of 4 judges, including, as you heard earlier, the former judge president of Gauteng, Judge Bernard Ngwepe, rightly took the view that in fact the main judgment didn't go far enough, as welcome as it is. And that is because there is in fact no place at all for criminal defamation in the first place. It's not necessarily about the sanction, it's about whether the crime itself is constitutionally justified. And that brings me to the earlier decision of 2014, the Zimbabwean Constitutional Court's decision, where the court unanimously struck down the crime of defamation. It held it was not reasonably justifiable in a democratic society. And the court's decision is profound for a number of reasons, and of course it was awarded this year's Columbia University Free Speech Decision of the Year. And that is competing with other countries such as the Turkish Constitutional Court's decision on Twitter and other very, very important free speech developments. But in the context of the arguable pressure that the Zimbabwean judiciary faces, this is an incredibly important decision, and it's an incredibly brave decision. It shows that this court, like ours, is truly independent of government and decides cases without fear or favor. What Judge Patel for the unanimous court ultimately decided was that the overhanging effect of criminal defamation is to stifle and silence the free flow of information in the public domain. This in turn may result in the citizenry remaining uninformed about matters of public significance and the unquestioned and unchecked continuation of unconscionable malpractices. And the court said the alternative remedy of civil defamation was sufficient to provide vindication to a person who has been defamed. and there was therefore no necessity for Zimbabwean law, in accordance with free speech in its constitution, to also have a crime of defamation. This finally brings me to South Africa, where I won't go into great detail because, as I say, Advocate Morrison will. Our Supreme Court of Appeal, in contrast to these decisions in 2009 in the Hoho decision, held that criminal defamation is constitutional. It rejected a challenge to the constitutionality. We thought at least we could distinguish that case because it didn't involve the media. But when a media defendant was involved, a media accused, that's Motsepe, as Moshweshwe has referred to, unfortunately we were not able to persuade the court that it was sufficiently distinguishable from the Hoho decision, and a different rule should apply to the media. There shouldn't be criminal defamation, at least for the media. Of course, it had a happy ending for Motsepe, the case, in the sense that his conviction was overturned, but that was on the basis of dolus eventualis, which anyone who followed the Oscar trial will, of course, be familiar with. But the judges expressly rejected the opportunity to say that our law has advanced and developed such that criminal defamation should no longer be a part of our law. So while other nations around the world and the continent have taken the correct steps to eradicate this unconstitutional crime from the law, South Africa is now a step behind. And as the minority warned in Konate, this is a step backward in the evolution of human rights in Africa. Hoho took that backward step, and the opportunity to correct it by the judges in Motsepe was unfortunately squandered by the court. My last point is that the minister's announcement today that the ruling party wishes to decriminalize the crime of defamation and that there will be engagement with civil society to achieve this is not only to be welcomed but to be celebrated. Eradicating criminal defamation from our law will do the legacy of Nelson Mandela proud. As he said back in 1994, with an eloquence no lawyer or judge has ever been able to match. A critical, independent and investigative press is the lifeblood of any democracy. The press must be free from state interference. Criminal defamation is exactly the kind of state interference which impacts significantly on freedom of the media in our democracy. The sooner we get rid of it, the better. Thank you very much.
Thank you very much, Dario. We're going to take a short break and we'll be back. Thank you.